Aloha, my name is Kenneth Lawson, and I'm your host of Life in the Law. And yeah, we got new mics today, too, and we got new guests for an exciting show. We have Williamson Chang, Bill Chang, from the University of Hawaii, Dr. Sai. You want to introduce Dr. Sai?
I'll introduce Dr. Sai. He got his doctorate in political science from the University of Hawaii. He also got a master's. He's an expert in all kinds of law, Kingdom of Hawaii law, international law, and even American constitutional law. And he's devoted the past, at least 15 years to the process of educating people, Hawaiians and non-Hawaiians. And so we're very fortunate to have him. He wrote his doctoral dissertation about the Kingdom of Hawaii, its continuity, and actually what comes after that.
And that's what the show is about today. A few months ago, and mind you, I was not born here in Hawaii. I'm from the mainland. I came here in 2008, and so a lot of the history of Hawaii I'm ignorant to. And so a few months ago, there was a whole bunch of news about the Department of Interior coming here doing hearings, and there was a whole bunch of hoopla with OHA and whether or not Hawaii should be considered a state, etc. All these things are going off in the news, and for a person like me, it was very hard to understand exactly what are the real issues. You know, what's this fight about? I knew that it was a lot of emotion involved. I knew that people felt very strongly on both sides of these issues, but I really didn't understand the history behind it and what the issue is about. You know, and that's what the show is about today. Can you explain to me what was the purpose of these hearings that the Department of Interior held?
Well, I'll tell you what, I'll speak to, in a very short period of time, what the hearing's about, and I think you can best speak to what the emotion was about. Mm-hmm. The hearings were about the failure to get Congress to recognize Native Hawaiians, and that's got to have a little blood, being Hawaiian, Native Hawaiians as the Indian tribe. They tried it for 10 years, and there's something called the Akaka Bill in Congress. Mm-hmm. Congress wasn't biting. So they moved it over and said, can the executive branch, can the President of the United States and the Department of Interior do it by rule? And somebody came up with the idea that it would be a good thing for President Obama, as a child of this island, to do this as he exits, to give Hawaiians what he thought they wanted, which would be federal recognition as a tribe. So the hearings were about, do you want to be a tribe? An Indian tribe recognized. There's 566 tribes that are recognized. People know them because of casinos, also the hard life on reservations. And so that was the issue. Do you want to be a tribe or not? And it did get emotional.
What's your position on that?
My position on that, well, is the same as Dr. Sai's. I think I'll let him speak to that.
It's really the emotions that were exhibited in these 15 hearings across the islands. The majority, and I would say the clear majority, I would say about 95% of the testimony was speaking to Hawaii as if it is not a part of the United States, and that the Interior Department should not be here, but rather the State Department, because we're occupied. Now, that exhibit of emotion stemmed from information that people just started to learn, and they began to ask the right questions, but they also utilized a lot of legal sophistication, where you have elderly kupuna. Kupuna in Hawaiian is an elderly person, speaking to a joint resolution of annexation, not having any force and effect beyond the borders of the United States. You have to think, where did NT learn that from? It's been part of an educational campaign at the University of Hawaii. I would say that began since we returned from the Permanent Court of Arbitration in the year 2001. Yeah. And that was a case in the Netherlands that verified Hawaii to be an independent and sovereign state, but under occupation. There was a deliberate move to return home and begin an educational campaign to start re-educating people. And that's what prompted myself to enter the political science department in 2001, January, and specialize in international relations and public law. And then I proceeded to get my PhD. So people like Professor Chang also has been teaching this. Other PhDs have come out teaching this. In fact, there are a lot of classes now that speak to this issue not as a political position, but rather as a legal reality. And that's very important.
But so again, you have to spoon feed this to me. You guys have been living this. You've been teaching it and educating people on it for years now. So going back to the Department of Interior hearings, what you're saying is that the federal government had no business even coming in conducting the hearings to make this determination.
Well, look at it this way. It would be like the Department of Interior, which is limited to interior matters of the United States, is in London asking the Anglo-Saxons if they want to be recognized as an Indian tribe.
And that makes it clear.
Yeah, I mean,
okay.
You got to make sure Great Britain is a part of the United States before you ask the Anglo-Saxons if they want to be a tribe. So I think that's a good comparison, you might say, that we have, because Hawaii was an independent state since 1843.
That was my next question. How legally, how did this happen? When you say it's a legal issue, it's not an emotional issue, it's not a political issue, because, well, we'll get to the emotion part of it a little bit later. But kind of explain the historical background factually on why it is you believe that Hawaii is being illegally occupied.
Well, I think we need to start off with Hawaii's sovereignty. Okay, so sovereignty under international law is supreme authority over territory. Okay, that exists independent of sovereignties over other territories, and that's why independence is a political independence. It's not a physical being of independent of someone who's subjugating you. Mm-hmm. So political independence is sovereignty. Now, in order to achieve that under international law, you need explicit recognition by the international community, bringing that state or that nation into the family. Okay, so a recent example of a nation that became an independent state, recognized as such, and became a subject of international law would be Palestine. So Palestine achieved the recognition of its independence on November 29, 2012. Okay, up to that point, Palestine was in the process by which they wanted to exercise self-determination to become an independent state. On November 29th, they achieved it. So Hawaii achieved that status on November 28, 1843, by joint proclamation from Great Britain and France. In 1844, the United States followed up with explicit recognition of the Hawaiian Kingdom as an independent state, President John Tyler, through his Secretary of State, John C. Calhoun. Okay? And since then, Hawaii's government, which exercises that sovereignty of this country, was a constitutional monarchy that had over 90 embassies and consulates all over the world. Okay. So Hawaii had a national population, a citizenry that was multi-ethnic, but the majority were Aboriginal Hawaiians, or the natives. Okay, so you had a ratio of 86% Aboriginal, 14% non-Aboriginal. So you could be black, you could be Chinese, you could be Caucasian, and still be Hawaiian. Because Hawaiian is short for Hawaiian subject, like British is short for British subject. Okay, so that's the nationality of the country.
Okay.
So when we now get into 1893, what we had there was an illegal overthrow of the Hawaiian Kingdom government, not the country. The purpose was to overthrow the government intentionally, led by the United States Ambassador, John Stevens, with U.S. Marines, in order to send insurgents, a very minority group of people, about 30 of them, send their representatives to Washington, D.C. to sign a treaty ceding the Hawaiian Kingdom, the Hawaiian Islands, to the United States on February 14, 1893. That treaty was then submitted to the U.S. Senate for approval. The problem is you have a new president coming into office on March 4th, and that's President Cleveland. President Cleveland receives a protest from the Queen, the head of state of Hawaii, saying this was illegal. U.S. troops were involved, a threat of war. So he went to the Senate on March 9th and removed that treaty from further consideration, and that's when he initiated a presidential investigation into the overthrow. By October 18th, 1893, the U.S. Secretary of State completed the investigation and notified the president, America's in the wrong. We were directly responsible for the overthrow of that government, and it's a friendly government, because we supported insurgents, and without our Marines there to protect them, they would have been arrested for treason. prosecuted, and convicted. So that began the process to negotiate settlement through what is called executive mediation between the ambassador to Hawaii, his name is Albert Willis, the successor of the former ambassador, and Queen Liliuokalani at the U.S. Embassy, or what we call a legation in Honolulu. And they negotiated for a month, and they came to an agreement. The president said, we are responsible and we have the duty to reinstate the government as it was before the troops landed. And the Queen, out of sympathy and at the urging of the president, would grant amnesty to all those insurgents.
Including Willis.
No, actually Willis was a diplomat, so he has diplomatic immunity.
Okay.
Yeah, so he went back home. So did the Marines. But everyone else who committed treason in Hawaii, which included Americans, British, even Hawaiian subjects, they would be granted amnesty after they're convicted. That's a rule of Hawaiian law. You can only grant amnesty after conviction, which is different from U.S. law.
Right.
You can grant amnesty before conviction. That was the basis of the amnesty proclamation by the president after the Civil War to the southern states insurgencies. Now, that agreement is a binding agreement, but it wasn't able to be carried out because Congress was playing politics. Because what was on the mind of the U.S. at that time was getting Hawaii as a military outpost. It was military buildup. That's what they wanted. So they basically prevented Cleveland from carrying out his duty to faithfully executing that treaty to reinstate that government. And Hawaii was thrown into civil unrest. That's when we jump ahead to 1897. A new president is here, President McKinley.
Well, let me back up for a minute legally then. If President Cleveland couldn't carry out through Congress and execute that treaty, what's the status of Hawaii then?
Well,
is it still? Go ahead.
That's a good point, because this is where in law and political science you have to separate the sovereignty of the state, which is the country, and the government that exercises that sovereignty. They're two separate entities. So a government can be overthrown without overthrowing the state.
Right.
Okay?
Mm-hmm.
Now, when a government is overthrown by a foreign state, you call that situation occupation. So, like in 2003, Iraq, when the United States military overthrew the Iraqi government, that did not equate to the overthrow of Iraq's sovereignty and its status as a state. It's occupation. That's what happened in 1893. So the overthrow of the Hawaiian government did not equate to the overthrow of the country. So what you have is civil unrest, and now it's turning criminal. And it wasn't a good time to live in Hawaii at that time between 1893 and 1897.
What was going on?
Well, because the U.S. Marines were withdrawn, the insurgency, which were businessmen, began to hire mercenaries out of San Francisco, former U.S. military, to replace them. So basically, Hawaii was a hostage crisis took place, and it all stemmed from the United States' deliberate failure to carry out that agreement, which put the Hawaiian subjects and the Queen in a dire situation. So that's when you bring up these issues of estoppel, legal principles where you cannot benefit from your own illegal act. But what it did was the law preserved the situation, but from a practical standpoint, it was crazy. It was crazy.
All right, we gotta go to a break real quick. Hey, this is good, man. I'm learning a lot. Hey, he's good, isn't he? All right, we'll be right back after this break.
Hi, I'm Donna Blanchard, and I host the show Center Stage on the ThinkTech Hawaii digital series right here every Wednesday from 2 to 3 Hawaii time. I would really love to have you watch the show and see what we do here. I talk with some of the most amazing people, artists, most of them, all of them involved in some sort of artistic process. And our goal here on the show is to dig into that artistic process, and you would not believe what some people say, what some people do, what people go through to express. And these are people who have to express somehow, and I find that infinitely interesting. Not only that they have to express, but how they end up doing it. I really hope that you will watch the show and enjoy talking with some of these people the same way that I do. Thanks, and I hope to see you soon on Center Stage on the ThinkTech Hawaii digital series, Wednesdays from 2 to 3. See you soon.
No, that wouldn't be.
Aloha, this is Ken Lawson again, the host for Life in the Law. Yeah, so my producer's in my ear telling me that I didn't really cut out from the break that good. Next time I'll try to do a little bit better. You got to help me out here, Bill.
Okay, I will.
But anyway, we are having a very good conversation with Dr. Sai and Professor William Chang from the University of Hawaii School of Law about whether or not Hawaii is a legitimate state, right? And again, I'm learning so much. Before the break, we were talking about what was going on back in the late 1800s. And I guess it was a rough place to live in the way you described it.
There actually are newspapers that people are now drawing from the archives that speak to that time. You know, in fact, I sat on a doctoral committee. One of our doctoral students who just recently received his PhD in political science, his focus was on Hawaiian nationality and how race began to be interjected since 1887, and really prevalent throughout that era or that time frame of when Cleveland didn't do his job. Yeah, it was an ugly time. In fact, Queen Liliuokalani, the head of state of a country, was portrayed in cartoons as a monkey. You know, it was bad. It was really bad.
Yeah.
You know,
yeah.
And you're talking. It wasn't just law. You had racism, but you see, you didn't have that in Hawaii. So it was like Hawaii was thrown into this bucket of race, and it was drowning, you know. But those are real issues, yeah. But I think we need to step back to see what was the timeline to understand what actually happened. So if I can get back to
remember the treaty had been signed, but it could not be carried out fully.
Yeah, and the reason why is because Congress would not authorize the use of force and appropriate monies to redeploy the troops. It wasn't that the president needed to go to Congress to approve that treaty. This was what is called a sole executive agreement, that the president had full authority to do on his own.
Okay.
Yeah, similar, but opposite from a treaty of annexation. That's when you need the Senate to get involved with that. So this agreement wasn't carried out. So President Cleveland basically a lame duck. He can't do anything. A new president comes in, William McKinley. Now William McKinley wants to entertain getting Hawaii one more time because they want Pearl Harbor. They want Hawaii as that military outpost.
They were strategic to what back then?
To protect the West Coast. To protect the West Coast of the United States. In fact, they were afraid of Japan, of an invasion by Japan. You know, Japan was a rising power. So there were some issues there that wanted to utilize Hawaii for strategic purposes.
And Japan probably wanted this land too.
No.
You don't think so?
No. Actually, Japan had a very good relationship with Hawaii, especially under King Kalakaua, where there was going to be set up a political confederation called Oceania, made up of Pacific states. But that's another show. So getting to President McKinley, he entertains these individuals again to sign another treaty. And he signed it on June 16, 1897. Now, these individuals are still criminals. They're insurgents. They weren't granted amnesty per the agreement. So they're just acting as a government. Okay. And they signed that treaty, and President McKinley is intent to submit it to the Senate. He's not listening to the Queen, who's in Washington, D.C. at that time, Queen Liliuokalani, where she filed a diplomatic protest with the U.S. State Department and said, this is illegal. This is a violation of international law. Word gets back to Hawaii to activate signature petitions, and they managed to gather 38,000 signatures. One was 21,000, the other 17,000. These signatures were then taken up to Washington, D.C. to be submitted to the U.S. Senate on the record when it convenes in December. Now, this is the summer, June 16th. The Senate is not going to convene until December of 1897. Representatives of these political organizations went to Washington and they met with Senator Hoare from Massachusetts, and he agreed to read these petitions into the Senate. But they agreed to only submit 21,000 because it protested annexation in any way, shape, or form, as opposed to the 17,000 that also protested annexation but called for the restoration of the Hawaiian monarchy. They thought that would be much, it wouldn't work well against the Senate. So they just said protest against annexation in any way, shape, or form. Those signature petitions of 21,000 signatures was able to make it where the Senate was not able to ratify the treaty. So by March of 1898, the treaty's dead. And that's when In April, Spanish-American War breaks out. Okay, the Spanish-American War breaks out. The Americans have to fight the Spanish, not just in Guam and the Philippines, which is in the Pacific, those are Spanish colonies, but also in Puerto Rico and Cuba, in the Caribbean. And then on May 1st, just 2 weeks after the war started, Admiral Dewey of the U.S. Navy defeats the Spanish fleet in Manila. And that's when Guam and the Philippines are occupied. And fighting will now continue in Puerto Rico and Cuba. The war is not going to end until December, so we're still at the beginning of the war. And I think this is where I can pass it off to Professor Chang, because now we're going to get into not a treaty, but rather a joint resolution that was submitted by Francis Newlands, a representative from Nevada.
So what Dr. Sai mentioned was this 1897 treaty that was the subject of these petitions from Hawaii and it never passed. Well, one of the reasons it never passed was because the constitutional rule for treaties requires the 2/3 majority of senators present for it to be ratified or passed. And that's a supermajority. You just need a 1/3 block to block it. It actually never went to vote because they knew they could never pass it. A man named John W. Foster, who was the former Secretary of State in 1893, the year in which the overthrow occurred, was traveling around and he came up with the idea of why not try a joint resolution. And he came up with that idea because he was under the belief that Texas had been acquired by the United States by joint resolution. He was wrong. It wasn't a joint resolution, it was a treaty, but he floated that idea of a joint resolution. Now, what's a joint resolution? A joint resolution is just a fancy word for a bill or an act of Congress, which requires the House to pass it and the Senate to pass it, and by how much? By just a mere majority. So do you see the thinking? You can't get the supermajority of 2/3, but we can get a majority. Let's pass a bill. So the joint in joint resolution doesn't refer to Hawaii and the United States, it refers to the House and the Senate. So it went through the House first, got passed, and it went through the Senate, and there was a filibuster against it, and you had senators, almost every senator protested it, except for 2, and they protested it on the grounds that it couldn't do what people were claiming it would do. It couldn't acquire the Hawaiian Islands. That was what the joint resolution was supposed to be, something in a substitute for the treaty.
Now, since we're talking legal, right, and there's evidence that demonstrates what these senators protesting were actually saying. I mean, is there a record of what they're saying?
I spent 20 years of my life reading that, and I brought it with me.
I think it's important for the viewers to know, because again, when we talk about this issue, and a little bit of research I did before we started the show, and again, I'm learning so much now, it shows it's a very emotional issue. So a lot of times people are saying, well, you guys are just saying this is your opinion, it's not fact. And since we're talking legal, since we're talking reasoning,
that's, I was one of those who were brainwashed. I was brainwashed in 4th grade when I asked my teacher, Miss Suzuki, how we became Americans. And she said, you were annexed by the joint resolution. And I said, really? Okay, and I believe that. All the way up until 20 years ago, when I had a hunch and I went to look at the congressional record of the Senate debate on the joint resolution, and I found people saying, what are you, crazy? How can a law of the United States reach out and acquire the sovereign territory of Hawaii? Because if the United States could do that by a law, couldn't Hawaii pass a law and acquire the United States? And there's only 2 senators who supported the joint resolution. One was Stewart of Nevada, and he said, we can annex the world. And he was a little lunatic. And the other one was Foraker of Ohio, who said, it's a treaty. You only need one party to sign a treaty of this kind because the other side died. And he was also kind of a lunatic.
Yeah.
But everybody was saying, what are you talking about? We can't do this.
But how did it pass both houses then?
Because it was a war. And during wars, presidents get a lot of support.
Yeah.
And during wars, the president wants, he wants Guantanamo Bay. You give him Guantanamo Bay.
It's the Patriot Act.
Patriot Act. And so he knew he could get a majority, and he got a majority in both. And the reason the official United States position as to how it acquired these islands, the Hawaiian Islands, is by this 1898 Act of Congress, which had no power. It's right on the record. It had no power. You had legal scholars saying, what's going on here? You can't take another country by legal legislative act. And you had in 1988 an opinion from the Office of Legal Counsel, the Department of Justice, answering the legal advisor to the State Department, and a question came up, how was Hawaii ever taken? And he said, frankly, I can't identify the reason and power behind which it was taken. Now here's the real...
It was magic.
Here's the real point. The point is the burden of proof, and you know about burdens of proof, we're going to discuss that later. Who has to prove something is on the United States. It has to show how it got Hawaii.
Where do you get that from?
That's international law. That's the law of jurisdiction. Subject matter jurisdiction. Who has the burden of proof? It's the party claiming jurisdiction. So for the United States to say in 1988, we don't know how we got it. That's like saying, I don't know how I got that bicycle, but it's mine. I don't have a receipt, but it's mine.
I said that a couple of times before, but that's another story.
Well, the thing is, just like a bicycle, a treaty is proof that you have a receipt for something. Now, we just talked about the two treaties that failed, one in 1893 and one in 1897. So they moved to a joint resolution, and it had no power to acquire the Hawaiian Islands. And so here's the story. They've been saying that since 1898.
Okay, but take me up when Hawaii became the 50th state. Does that X out all the other mistakes in the past?
No, sir. The reason why is because if a joint resolution is an act of Congress, you agree?
Yeah.
Joint resolution is an act of Congress.
I'm on a witness stand now. Yes, yes.
And can't take Hawaii. What's the act of admission? An act of Congress. How can an act of Congress in 1959 do what an act of Congress couldn't do in 1898? Right?
I don't know. You're losing me.
Okay. Acts of Congress cannot take other countries.
I agree with that.
Okay. The joint resolution is an act of Congress. The act admitting Hawaii as a state is what? An act of Congress.
That's what you're saying.
Okay. Now, the other point I want to make is, this is something I did more research on. The act of Congress by which it admitted Hawaii as a state, it admitted that it couldn't take the Hawaiian Islands because if we look at the territorial boundaries it described for the state of Hawaii, it said what's in the state of Hawaii are islands that were acquired by the joint resolution. Now you think about that. What islands were acquired by the joint resolution? The joint resolution we just discussed had no power to acquire any islands. And then in 1959, they defined the state of Hawaii. And this is in the books, in the Hawaii Revised Statute, Section 2 of the Admissions Act and Article 15 of the state constitution. What's in Hawaii are islands that were acquired by somebody that couldn't acquire it. So there's no islands in the state of Hawaii. By U.S. law itself, there's a confession, and you know about confessions. You know about admissions. You know about when you confess, I don't have Hawaii. That's what the United States said in 1959. So two reasons why the Statehood Act did not take Hawaii. Number one, it had no power because it was just an act of Congress. And we established that as a precedent with the joint resolution, which was the act of Congress. Number two, they said so. They said they were honest for the first time, but they really just, kind of described it in a way that fooled everybody. I mean, we're all fooled.
But is this different? Is what happened in 1959 different from what happened in Alaska when it became a state?
No, Alaska.
There was a treaty.
Well, it was a treaty of 1867 between the Emperor of Russia and the United States, and there's a treaty, and it's the boundaries. You get to the boundaries. It's so well described. It's by meets and bounds, and from this mountain to that river, and little islands are described. So it's really clear.
I understand that, but my question is, at some point after the treaty, an act of Congress brought that in as a state, brought Alaska in as a state.
No, it was a treaty that brought Alaska in.
See, an act of Congress can only work within U.S. territory. Okay, so for Alaska to have a state government created by Congress in the 1950s, it was predicated on first that Alaska was a part of the United States,
I got
and
you.
that's the treaty that Professor Chang
U.S.
was referring
territory.
to. Yeah.
All right, we're going to go to another break. Let's see if I do this right, Zuri. All right, we're going to another break, and we're going to come back to life and the law with our special guests, William Chang and Dr. Sai, and we'll close out on this topic.
Aloha, welcome to ThinkTech Hawaii. My name is Josh Green. I'm the host of a program called Healthcare in Hawaii. I'm a physician. I work in the emergency department on the Big Island. I also serve in the state senate, which, please don't hold that against me, doesn't detract from my television program. We speak about all the big healthcare issues in the state. We get together on Tuesdays from 2 o'clock till 3 o'clock in the afternoon, and we try to talk about the most important issues in healthcare. This is a terrific venue for people to learn about healthcare. There are many programs on this station. We broadcast it later, not just on the internet, but also on OC16. Thanks for joining us. Please be informed healthcare consumers.
All right, we're back with Life in the Law. I'm your host, Kenneth Lawson, and we're here again with Dr. Sai and Dr. Well, actually, you seem like a doctor, but you're Professor William Chang. And we're talking about, again, the difference between a treaty, which is what we had with Alaska, and that's how Alaska became a state, because it was a U.S. territory before it became a state. The position here is, and the facts here, is basically Hawaii's never been a U.S. territory, and an act of Congress can't make it a state.
Right.
See, I'm learning.
You're learning. The point here,
You're a good teacher.
the point here, and Senator Allen said this on page 6636 of 31 congressional record. In July 4th of 1898, he said every territory acquired by the United States is acquired by treaty. That's true. And he said you can't do it by joint resolution. He said, you know, what happens when someone charges and asks by a writ of quo warranto, which is saying, by what authority do you have that you exercise sovereignty of Hawaii? What are you going to say? The question comes down to a real simple one. As Dr. Sai pointed out, Hawaii is a nation. He established that in the Court of Permanent Arbitration. As of 1843 and 1844, here's the question. What act by the United States changes that? And we went through, you need a treaty, you can't use a legislative act. The two treaties failed. The legislative act had no power to do it. So we're like still in existence. And there's a presumption of continuity that Dr. Sai can talk about.
So when you speak of a presumption is a conclusion based upon evidence that shifts the burden of proof.
Right.
Okay. So the presumption of innocence. The person has rights, so the burden of proof lies on the prosecution to prove beyond a reasonable doubt the person's guilt. Meaning that individual with the presumed innocent is not required to prove they're innocent. Okay. Their innocence is the presumption. Okay. The argument against that presumption has to be based on evidence. You have a very similar rule under international law called the presumption of continuity of an independent state. So the presumption of continuity says that a state will continue to exist despite its government being overthrown. Even a state will continue to exist when it's occupied and there is no government claiming to represent the occupied state.
Like Iraq.
Exactly. That's the presumption.
Okay.
So there was no sovereignty movement in Iraq to prove Iraq was still a country. It was a country, it was occupied. The issue was now to deoccupy, deoccupation. Now for Hawaii, this presumption rule can only apply if two things are met. First, there has to be evidence that the Hawaiian Kingdom did exist as an independent state in the 19th century, that it did exist. And the Permanent Court of Arbitration verified that in its arbitral award, where it explicitly stated that in the 19th century, the Hawaiian Kingdom existed as an independent state, recognized as such by the United States of America and Great Britain and various other states. So that fulfilled that first element. The second element is, has there been any intervening events that would have changed that status? Now we're looking at the joint resolution. Obviously the joint resolution has no effect on that status because it's a U.S. law, limited to U.S. territory. It's not a treaty or an international law. So the presumption of continuity is in favor of the country called the Hawaiian Kingdom. The burden of proof now shifts. It's the United States of America that has to show that it extinguished the Hawaiian Kingdom.
And that may all be true, but what do you say to people who say, you know what, so what? Who's going to decide this? And then have the power, let's say that you're right, who's going to decide the legal issue, and then have the power to tell the U.S. that you no longer can say that Hawaii is a state?
Well, those issues are what you utilize to get this word out is what is called the International Laws of Occupation, called the Hague and Geneva Conventions, and also international humanitarian law, the protection of civilians during occupations, okay, and Hawaiian Kingdom law. So when you start to look at the issue of Hawaii being occupied, just to spread the word that Hawaii is occupied and the presumption that applies, people now will quickly realize, wait a minute, what about the taxes that I've been paying to the United States and the state of Hawaii during the occupation if they didn't have any authority? Then that means that was not taxation, that was theft. And that's called pillaging under international law, which is a war crime. Now individuals could seek redress. That's just one example. If I'm Russia and I'm looking at this situation, I'm seeing Hawaii's occupied, the Hague Convention, number 5, prevents neutral countries to be occupied by belligerents. Okay.
Right. And let's say
no, but let me finish with this. So
ahead.
Russia now has a vested interest to end the occupation in order to get the military out of Hawaii. So there's many different aspects of how people can see this and utilize it.
But who's gonna sit and arbitrate it and then say, okay, I have the power to force the United States to deoccupy Hawaii?
It falls under the rules of occupation. The Geneva Convention calls for protecting powers. These are other countries that can be approached.
That's what I'm asking.
Yeah.
So other countries would have to come in and tell the United States, we all agree you did Hawaii wrong, you should be out.
You've got a very good point. International law differs from law of a country because it's hard to enforce or impossible to enforce.
Right.
President Obama today is in Estonia, and he's giving a speech. He's giving a speech because Estonia once was an independent country, got invaded and taken by Russia after the Russian Federation broke up, came free again, like Hawaii, and President Obama is saying, you were invaded once, NATO is not going to let you ever be invaded by the Russians again. So it is international opinion, the Security Council, the only powers really out there are powers of persuasion, military force, coalitions. The question is, the United States proclaims itself as the defender of the sanctity of states, of sovereignty, and when you look at the United States, 120 years of illegal occupation of the state of Hawaii is a very dark blotch on its ability to lead the world as the one that's going to enforce this idea of non-intervention.
So let me ask you a question. Let me ask both of you guys a question. So let's say the United States says, you know what, you're right. We looked at the records, we agree with you, we're deoccupying, we're out of here. What happens to Hawaii?
Well, it goes back to what it was. It transitions to the present, and it operates as an independent state with free trade and all those treaties that still exist, including their successors.
Who protects us from foreign invasion?
Well, Hawaii has its own military. In fact, today's Army National Guard and Air National Guard is a direct extension of the King's Guard and the Queen's Guard of 1893. You know, so we're like Switzerland. We're a neutral country, it's in our treaties, but we also have a military. You know, so we really just go back to what it was, and we move forward.
So do we have a king and a queen?
It's a constitutional monarchy. It's a limited monarchy. It's a government that is unique unto Hawaii. Now, that government has to be reinstated according to the agreements. Now, where it moves after that, that's up to the people to decide. You know, that's the legislative process. That's the political process. So it's no different than any other country.
You have to remember that the political growth as a nation of Hawaii was stunted and stopped in 1893.
I agree.
You know, if you go back 120 years and look at any country, they're going to have rules that reflect a period of time of that. Hawaii can evolve, could have evolved, and probably would have evolved. Some of the benefits that might come from being an independent state, independent kingdom, are, for example, the Jones Act. The Jones Act says only between American ports, you got to have American ships carrying trade with American crews flying an American flag. That means we can't have lower cost competition like Korean shipping or Chinese shipping carrying goods in between Los Angeles and Honolulu. If we were an independent state, we wouldn't have the Jones Act. We would have the ability to lower the cost of living. We could control our immigration. We can control the number of wealthy people coming in and buying up second homes. We could have a better life.
Let me ask you a question. Let's say that the United States says, okay, you're right.
Okay, wait.
Let me. I gotta ask this because you guys have been living with this, but for people like, but they said we'll leave it up to a vote of the people on the island.
No.
What would happen?
Okay, when you're kidnapped for 121 years, the kidnapper doesn't say, okay, do you guys want me to still be your dad? You know, it's a criminal situation. So what we're doing here is we're exposing Hawaii's history, not to get the kidnapper to admit he's a kidnapper. He's a kidnapper. Remember, the presumption is in favor of the hostage, not the kidnapper. So it's really an issue of the consequences of exposing the situation, and it begins with the exposure. It's consequences.
Look, if I'm a juvenile and I'm in a forced marriage, and I don't want to do it, but my parents have forced me to do it, and I'm marrying this woman who I don't want to marry, etc. But over years, I'm okay with her.
Right? There's no marriage.
So what I'm saying, what do you say to people who say, you know what, you may be right, but I'm okay with the way things are? That's my point.
Well, I mean, those are good points, but it's not legal because it could be considered criminal. Okay, so when we're looking at, I just want it the way it is. Well, what if that statement actually violates a particular law that's called a war crime? And if you're saying, well, nobody's going to touch me because the United States is here, well, what if that ends? There's no statute of limitation on that. So the real issue is slow down, don't jump the gun, get educated. Now the consequences are very profound, and we're not going to get it all in 45 minutes. But here's one example of the profound effect of this information. Article 2 of the United States Constitution says that the president must be natural born, native born within the United States.
Mm-hmm.
Okay. The presumption of continuity is in our favor. The Hawaiian Kingdom is not a part of the United States. Barack Obama was born in Honolulu. He was born of an American parent, so he's an American citizen. But he was born in a foreign country. He's not natural born.
Well, you probably get a lot of people out there supporting you on that, man, from the mainland.
It's like why the birthers are right for all the wrong reasons, you know.
Yeah.
But again, that's just the consequence. It's a casualty of this information where we all began to wake up to this reality of, wait a minute, we were living in the Matrix. You know, it's like the movie The Matrix. And the only way you get out of the Matrix, you got to get unplugged. You got to take the red pill. And when people start to take the red pill, it gets a little scary. But you just got to get used to it. The key is education.
Yeah.
Education. And that's why at the University of Hawaii, Professor Chang teaches it. I'm at Wimmera Community College. I teach it. And we're actually co-teaching a class at the law school. It's information. That's the key. Yeah.
I think it's important. Yeah. And you know, I've learned a lot sitting here with you guys today. You know, I enjoy this. But actually, you're right. It's the education is the key, and I guess that's, like you said, slow down, get your education first, and then make decisions.
Exactly.
All right, that's all the time we have for today. But Professor Chang, Dr. Sai, again, you guys are teaching a course at the University of Hawaii.
Right.
You frequently, you got a website too that.
Yep, actually people can go to hawaiiankingdom.org/blog that has updated information, or also hawaiiankingdom.org, and that has information on laws of the kingdom, the laws of occupation, and everything else.
All right, again, it's your host, Ken Lawson. Join us next week on Life and the Law. I have absolutely no idea what our next topic is going to be about, but I guarantee you it's going to be a lot of fun. See you then.